Welcome and thank you for joining me in this video. My name is Fred Long. I am a Pennsylvania estate planning attorney. And in this video, we're going to talk about what happens in Pennsylvania if you die without a will. But first, I want to talk about the types of assets that this video will not address. Those are things like retirement accounts, IRAs, life insurance, anything with a beneficiary designation set up, or jointly held assets, payable on death, transfer on death, things like that. Unless those assets specifically name the estate as the beneficiary, then those assets will pass outside of the will. They are considered non-probate assets. So in this video, we're going to talk about probate assets, things that flow through the estate, either through your will or by the state's intestacy laws. So now let's cut to the main video. What we're going to address today is what happens when somebody dies without a will. When someone passes away and they don't have a will, they are said to have died intestate. And so to determine what happens, how their property is managed and ultimately distributed, we have to look at the law books. We have to pull them off the shelf, dust them off, open them up, and take a look. What do the intestacy laws do? The intestacy laws are kind of like the state's way of saying, hey, if you didn't do what you knew you probably should have done and go and draft a will, you don't need to worry because we have you covered. The intestacy laws outline, in order of priority, who is set to receive distributions from your estate. And the highest priority are surviving spouse, children, and then parents. And then you can kind of go down the list. And I can't remember exactly how that order of priority falls, but you look at relationships like nieces, nephews, siblings, and other familial bloodline relationships. The likelihood that your property will pass to the state, or what's called escheat to the state, is very unlikely. That would basically mean that you have no living relatives at all. What's really interesting about these laws is that the likelihood that they are aligned with what most of us might think would happen is probably very low. So what I mean by that is, if you would take a guess, if I would say, hey, what do you think would happen to all of your stuff if you die without a will? The likelihood that most people would get that answer correct is pretty low. So I'm going to give you a couple of examples to illustrate this. The most common example is when somebody dies without a will and they have a surviving spouse and they have children. What happens in that situation is the surviving spouse will inherit the first $30,000 and half of the rest of the decedent's estate. And then the surviving children will inherit the other half. Two caveats to that. Number one, we're talking about Pennsylvania law. I just want to remind everybody that this is Pennsylvania specific. The other one is that if the children are children of the decedent but not the surviving spouse, then everything's split 50-50. 50% to the surviving spouse, 50% to the surviving children of the decedent. Another interesting example of what can happen when someone dies without a will is the scenario where you have a spouse, you're married but no children, and you have surviving parents. What happens in that case is the surviving spouse gets the first $30,000, just like the previous example, half of the rest, and then the surviving parents get the other half. So this is kind of unusual in the sense that more often than not, your surviving spouse, especially in that scenario, and especially if you're young, is probably going to benefit more from inheriting what you own than your parents. Not that that's always true, and maybe some people would want to ensure that their parents get something, but I just think it's an interesting result. I think most people would say, if I die, I just assume that everything passes to my surviving spouse. And I think that is a reasonable assumption, but it's not true. Pennsylvania intestacy laws, I think, have some kind of strange results. And so where does that lead us? The call to action in this video is that I would encourage you not to rely upon the state's intestacy laws to yield the result that you would want. And the truth is that the cost of preparing a will is almost certainly less expensive than the cost of unraveling someone's estate when they don't have a will. And why is that? Well, if you don't have a will, you haven't appointed an executor, somebody who has legal authorization to manage your estate, to bring in all the assets in one place together, to pay off the bills, to pay taxes, and then to distribute to your heirs. And if there hasn't been a person that you've decided that will fulfill that role, the court has to find that person for you. And what that means is that someone will have to file a petition in court asking a judge to make a decision on who is best fit to serve in the role of the administrator, which is effectively the same thing as an executor. It's just a different name because the judge appoints it rather than the decedent. But the role is the same. And the problem is that to get to that point where a judge would make that decision, you have to file a petition. You potentially have to hold a hearing, appear in court, probably with a lawyer, in front of a judge. You have a stenographer, you have all of the people who have to receive notice under the law that this is taking place, have an opportunity to show up and vie for their right to serve in that role. So the call to action is to plan ahead. Don't leave your legacy to the will of the state. If you like this video, if you like this content, please let me know, and I will look forward to seeing you in the next video.